Lori Vallow Daybell. She's the infamous Doomsday Mom, convicted and serving 3 life sentences in Idaho for the deaths of J.J. Vallow, Tylee Ryan, and Tammy Daybell.
Question number 1. In regards to count 1 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of conspiracy to commit first-degree murder of Tylee Ryan and grand theft by deception? Answer, guilty.
Convicted of conspiracy to commit murder in the death of Charles Vallow.
Guilty. Did you expect that?
No.
Not at all.
I mean, obviously I knew that's a possibility.
And now she's preparing to represent herself for the second time in Arizona. This time, the twist is that her alleged victim, Brandon Boudreaux, is the only survivor of her months-long killing spree that started in Arizona in 2019. As she prepares for her 3rd trial, it's critical to look at the evolution of Lori Daybell's defense, starting with her handwritten motions way back at the beginning of December of 2024, and culminating in her latest motion, a filing for a completely new trial. Her first motions contain some words in all caps, underlined for dramatic effect, hyperbolic language when referencing things like Court TV, running a nonstop commercial featuring Lori and Chad. The style of those motions reminded me of the similarities between Lori's language and that of her father, Barry Cox. Anyone who has read the introduction to his book about taking down the IRS will recognize the inflammatory language, the all caps emphasis, and the references to the virtues of the Founding Fathers and the Constitution. So if we want to understand more about Lori Daybell, especially the lawyer Lori, we need to understand her family of origin, and specifically her father, Barry Cox. Let's go all the way back to Texas at the turn of the century, the 20th century. Lewis Bramlett Cox, Barry's father, Lori's grandfather, was born on the 4th of January in 1914 in Grayson, Texas, a tiny suburb just north of Plano. His parents were from Mississippi. His father, James, was a farmer, and his mother, Vera, was a post office clerk. At the age of 16, he was living with his family in Happy, Texas. Happy is just south of Amarillo, Texas, and Lewis was working as a drugstore clerk. Now, Happy, Texas is close by to Texas Tech University, which back in the 1920s and 30s had a robust home economics degree program for women. Enter Rowena Lucille Robeson, who was born on the 6th of March, 1919 in Beaver, Oklahoma. Her parents, Clyde and Etta, were married in Oklahoma in 1909. Her father was a veterinarian from Indiana, but by the time Rowena was 11 years old, her parents had divorced, and she had moved with her mother, who was from Texas, and her younger brother to Lubbock, Texas, where her mother worked as a presser at a laundry. In 1937, at the age of 18, Rowena enrolled as a freshman at Texas Tech University, majoring in home economics. She was already married to Lewis Bramlett Cox, and they welcomed their first son, Jan, on May 3rd of 1938. 3 years later, the Coxes had moved to Los Angeles, California. The census for that year indicated that Lewis was working as a root salesman for the Jewel Tea Company. On June 11, 1941, Barry L. Cox was born. In a later biography, Barry claims to have born in Long Beach, which is technically a part of LA County, but a voter registration card for Rowena in 1946 indicates that she lived in what is now West Hollywood. On January 14, 1945, Lewis was drafted into the Army and was honorably discharged just a year later. By 1950, the family had moved to the LA suburb of San Bernardino. Barry would have been 8 years old at the time, and Lewis found work operating a grocery store. In 1957 and 58, Barry Cox can be found in the yearbook of San Bernardino High School, from which he graduated, and then later attended San Bernardino Valley College. This must have been the approximate time frame when Barry, and at the very least, his father Lewis, joined the Church of Jesus Christ of Latter-day Saints. LDS missionaries made a habit at that time of targeting college campuses, and Barry's biography notes that he served an LDS mission in England from 1963 to 1965. Most young men served at the age of 19, but it would make sense that Barry, as a convert, would have served slightly later from the ages of 22 to 24. The same year that Barry returned from England, 1965, Barry's father, Lewis, opened a drive-in hamburger joint, which he called Barry's Better Burgers. The architecture of the place he took over was patterned after the original McDonald's design, and it's apparent Lewis fancied himself as a franchisor, according to ads in the local paper, for people to invest $12,000 to $20,000 for entry into, quote, the burger business. This location closed in 1979 and became La Rosita. In 2016, the building was demolished and rebuilt in the original image as a Starbucks. The following years were full of huge life changes as Barry wasted no time starting a family. Shortly after returning from England, Barry married Janice Lee Connor of Rialto in Sacramento, California. Janice was pregnant with their oldest daughter, Stacy, who was born 7 months later. But while Janice was still pregnant with Stacy, Janice's father, my grandfather, died in January of 1966 in a military hospital following a routine surgery procedure. He was just 45 years old. 2 years later, in 1968, the Cox's first son, Alex, was born, followed by Adam just 15 months later. And 2 years after Adam arrived, Janice and Barry welcomed a second daughter, Laura Lee, who they called Lolly. Unfortunately, Lolly was born with a congenital heart defect, and she died just 6 weeks later. At a later family funeral 40 years after Lolly's death, I was in the Riverside Cemetery where Lolly was buried with my parents and Janice and Barry. Janice brought along baby wipes, which she used to lovingly clean Lolly's headstone. Barry talked of how heartbreaking it was to lose his infant daughter and how nobody could imagine that grief, even all these years later. Sometime later in 1971, Barry Cox ran for city council in Rialto, California. A newspaper article featuring his candidacy noted that his campaign platform included long-range city planning to prevent the oversaturation of any one type of business, supporting programs for the youth and elderly, and reducing all unnecessary spending. 2 years and 2 days after the birth of Laura Lee, Lori Noreen Cox was born, June 26, 1973. This brought the Coxes to a family of 6 with 4 children, 7, 5, 4, and newborn Lori. I was born a year and 4 months later. My parents already had a son the same age as Lori, and my dad's younger sister had married and had a son as well, so I was born the 7th grandchild on that side of the family. Sadly, my grandmother, who is my dad's mother, whom they all called Noni, died less than 5 months after I was born, in March of 1975. The Cox's youngest daughter and last child, Summer, was born in September of 1975. By this time, Barry had become a life insurance salesman in San Bernardino, California, for the LDS Church-owned Beneficial Life. According to an ad taken out by the company, he had a stellar year in 1975. And in January of 1976, he was named Beneficial Life's New Man of the Year, earning him the honor of serving on the council that advises the company president. The ad states that Barry specialized in business and estate planning and sold over $1.5 million in new life insurance policies in 1975. The last line of the ad reads, "Barry Cox is one of the best. Call him for sound insurance and estate tax counseling." You'll want to remember that last part. 1981 is the first year that I remember visiting the Coxes in California during the summer. I was 7 years old, and I was so excited to see the ocean and swim in the Coxes pool. During our summer visit in 1983, however, my parents decided that they would take my 2 younger siblings to stay with Noni's widowed husband, Lloyd, who lived 1 street over from the Coxes in Rialto. They allowed my older brother and I to stay with the Coxes since we cousins were all so close in age and old enough to enjoy the pool together. It was on this visit that Barry took Stacy, Lori, Summer, and me on several errands with him. We visited his office in downtown San Bernardino. He took us to see the movie Rambo at a local theater. We bought supplies for the pool, and we also went to the stables to visit Barry's new racehorse named Silk Panties. The implication was that the horse was owned by the Cox family, but according to state business filings, Barry was the agent of record and member of Henderson Farrier Service, with a business address located at the residence of the owner, Wallace Henderson. For those not in the horse business, a farrier is an individual who cares for horses' hooves and maintains their horseshoes. Knowing now more than I obviously did at the age of 8, I suspect that Barry was, at most, a partial owner with an interest in any winnings that the horse might earn. In 1988, my parents received a wedding announcement in the mail. It was a picture of the LDS temple in Laie, Hawaii. On the reverse side, standing on the beach with his pants rolled up and his feet in the sand, was Steve Cope, and he was holding a glowing Stacy Cox in a bright white ball gown. The announcement was that Stacy and Steve had eloped to Hawaii and were sealed in the LDS temple. Stacy was a student at BYU, and my parents and I had lunch with them in their basement apartment near the Provo campus the following summer. Steve made burgers for us, and I remember being impressed that he helped clean up the kitchen afterwards. I was taken aback, however, that he used soap on the wooden cutting board. We weren't allowed to do that at my house. In any case, I very much saw that visit as my dad's opportunity to suss out whether Steve was a deserving companion for his niece, Stacy. If he didn't pass, I wasn't aware. My dad only spoke kindly of Steve until their divorce was started just 6 years later. The divorce documents, which I will get into in a moment, detail Stacy's illnesses and Steve's fears over her parenting of their only daughter, Melanie, who was born in 1989. Getting back to Barry, the 1990-1991 timeframe was a difficult one for the former Man of the Year. Barry's father, Lewis, owner of Barry's Better Burgers, died in August of that year, and Barry was busy making false statements to the IRS, which would come back to haunt him later. In 1992, Lori graduated from high school, quickly married Nelson Yanes, and then divorced him just a few weeks later. She moved in with her brother Adam in his Austin, Texas apartment, and Adam was working as a primetime radio DJ at the time. Lori was working at a tanning salon, and she later got her cosmetology license and became a hairdresser. I graduated the same year as Lori, and the following spring in 1993, I moved in with Adam and Lori and got a job at the same tanning salon as Lori. I was there for just a few months before Lori had me removed by my Aunt Janice. I went to San Antonio to live with my parents. It was in San Antonio that I became engaged and started making wedding plans in January of 1995. I considered the apartment incident water under the bridge and called to ask Lori if she and Summer would be bridesmaids at my wedding in the spring of 1995. Later that year, Lori brought William LaJoya, who she called Billy, to Adam's apartment, and according to Adam, Lori announced that Billy would be moving in. Adam told them no, and so they got their own place and later married. Billy is the father of Lori's oldest son, Colby Ryan, who was born in 1996. Lori and Billy would later divorce, just 2 years after they married. 1995 was also the year that Janice and Barry bought a home near the LDS Chapel in North San Antonio, moving into a spacious new build with a hot tub, pool, and enough room for Alex, who drifted in and out of their house as he moved from job to job. They would also make space for their oldest daughter, Stacy, after her husband, Steve, filed for divorce in August of 1995, asking for full custody of their daughter, Melanie. I want to continue with these divorce documents because not only is the divorce of Steve and Stacy and the fate of Melanie relevant to the story and very important to the timeline of the trial that Lori is about to undertake, but this story tells us a lot about Barry Cox, his character, and the way that he interacts with his children. Now, all of what I have shared so far in this video is publicly available information, including this divorce document, which was made available by a FOIA request. So Steve Cope was living in Washington State at the time that he filed for divorce from Stacy. What we're about to read is disturbing information at the very least. It's a part of my family history that I wasn't actually aware of until I saw this document. Many of the family stories and rumors surrounding Stacy and Steve's relationship were tainted for me by what I'll just call the family narrative. The family narrative is that Steve was evil and horrible, that he badly mistreated Stacy, and that he was trying to steal Melanie away to get custody of her, just to hurt Stacy. In fact, it really wasn't until the time I started digging into the details around Charles Vallow's death that I realized patterns had emerged in the Cox family. And it didn't necessarily start with Lori. You see, Lori, based on my experiences with her, had a pattern of discarding people from her once she felt that they had outlived their usefulness. She did it to me in the apartment. She did it to her husband, Joe Ryan, just a week after she lost the Mrs. Texas pageant, and it appears she had done it with Charles as well, discarding him in favor of Chad Daybell, who told her that she was a goddess and that she had incredible spiritual power. Lori's particular pattern of discard involved three basic elements. First of all, making up a story about the person she was ready to discard that had some elements of truth, but really exaggerated the person's bad behavior and sometimes even projected her behavior onto the person she was trying to discard. The second phase of her plan was to tell her whole family the made-up story and to tell them not to talk to that person, essentially isolating them away from the family. And the third part of the plan involved getting family members on board to vilify this person and get them out of Lori's life. I recognize this as a pattern with Lori, but it wasn't until I read the divorce documents from Steve and Stacy's divorce that I realized a similar thing had happened in this instance as well. I remember Janice and Barry telling us all kinds of horrible stories about the way that Steve was treating Stacy and that he was trying to kidnap Melanie and keep her away from the family. But what I realize now after reading the documents is that Steve was a good father who was trying to take care of his daughter and keep them away from the Cox family. Once we read the documents, I think you'll be able to see why. Steve writes, 1. My wife presents a sad, even pathetic case which unfortunately threatens grave and irreparable harm to our child Melanie, age 6. It is with great sadness that I seek these restraining orders, but I believe that unless I'm able to protect my 6-year-old daughter Melanie and to provide a stable environment for her in which she is able to live and function in a normal fashion, that she will be irreparably harmed, far more than she is now. At this point, Melanie has missed over 6 months of school. Enamel on her teeth has not developed correctly, and she has developed some bizarre behaviors. However, the situation has come to the point where, in order to protect Melanie, I must act in a fashion which conflicts with what Stacy might desire or even need, and my wife appears to be either passively and or actively. I believe that she needs to commit herself for long-term care, but she has refused to undertake the measures the doctors recommended. It is my understanding that working with our church, we will be able to provide her with some location where she's able to exist while she makes her decisions. Through a combination of physical, psychological, and emotional factors, my wife Stacy has come to the point where her obsessive behaviors and habits are irreparably damaging Melanie. Stacy has a form of diabetes requiring regularly injected insulin, which she administers only sporadically. From about November 1993 through February 1994, Stacy enrolled in a correspondence course in naturopathic medicine. She began eating more, exercising less, and reducing her insulin injections, counterproductive to management of diabetes. From about that time, Stacy had acted on notions which have interfered with her own treatment and health. See below, but more relevant, have affected her ability to function as a parent for Melanie and have done irreparable damage to Melanie. Melanie's teeth, mental health, and attendance at school. I'm not sure what the ultimate cause is of Stacy's condition or whether the condition is now irreversible or if there is a cure, but I do know that she is out of control and unwilling or unable to set limits on her behavior. She must not involve Melanie in her obsessions. Those obsessions include beliefs that food is evil and contains germs, and even that socializing with other children is contaminating. And I believe she's either actively or passively. Number 3, Stacy has interfered with Melanie's entering and attending school. Melanie has a deplorable attendance record for last year at school for the times when she was not in Los Angeles. Even though left to her own devices, Melanie enjoys interacting with other children, attending school, etc. Stacy showed traces of Epstein-Barr in 1994. She concluded without any warrant that Melanie has Epstein-Barr. I, as well as the wife of the bishop of our church, had arranged for Melanie to be driven to and from school so that whatever Stacy's condition, Melanie can have time away from the house. To no avail, as Stacy simply dismissed those efforts. If Melanie said, "I'm tired" or "I don't feel good," without further inquiry or effort, Stacy would not send her to kindergarten. In October 1994, I made Melanie a wooden puzzle with 17 pieces, each of which was to be glued on for each day of kindergarten attended. It took 40 days for the puzzle to be completed. I feel that contact with the other children is essential. I had perfect attendance records for 3 years in my elementary school, and I am adamantly opposed to keeping Melanie away from school as it deprives her of a normal socialization experience. Yet, unless I remain at home to counteract Stacy, by default, Melanie will not go to school. 4. Stacy now detects her own problems in Melanie and has begun to impose her own peculiar notion of medical care upon Melanie to Melanie's detriment. Stacy has imposed a whole other range of fears and alleged conditions on Melanie. Stacy has a sugar problem. She concludes that Melanie cannot eat sugar and will hide in order to eat any of a whole host of forbidden foods which are generally accepted as good for children. Just as a side note here, I remember specifically Janice boasting that Stacy was teaching Melanie not to eat any candy and not to drink any soda. Melanie would parrot, "No candy, no Coke," and Janice was very proud of this fact. Stacy believes milk is bad and only for cows. Melanie is not allowed milk, and these foods are not allowed in the house and are returned if I buy them. Stacy fears the dentist but has excessive tooth decay and oral hygiene problems due to her high blood sugar. Melanie now fears the dentist. Melanie's last 2 lower teeth came in without enamel due to a lack of calcium at the time they were growing in. A recommended treatment is fluoride pills, which Stacy has refused to allow as it is unnatural. 5. Stacy has developed a paranoid fear of various foods, whether for her own use or for those of others. Among her beliefs are the following. Cucumbers and tomatoes must not only be peeled, but also washed before peeling to avoid pesticides and germs. Milk is a bad food, and Melanie cannot drink it. All foods are the source of germs, and all must be scrubbed excessively. Initially, insulin was the enemy, but from mid-1994, any food that might have sugar is not tolerated in the house and has become the enemy. By October 1994, Stacy had dwindled down to 76 pounds, about 30 pounds under what she should weigh. Although I do cook our evening meals and have attempted to keep the house stocked with food, Stacy made it a habit to return to the store virtually all the food I had purchased. Often when I've gone to the pantry in preparation for cooking a meal, I've found that there is literally nothing there, although I had just gone shopping. Melanie has become the caretaker for her mother, believing that she is responsible for her mother. Stacy has only one other close friend in Washington, Linda. She rarely leaves the house and has gone to church but once or so in the last 8 months. Melanie will not go to church without her mother, so none of us go. The effect is that in her mother's presence and given her mother's demands, Melanie sacrifices her own childhood to caring for her mother. When she plays outside, Melanie checks back in frequently, but in order to check on her mother, not the other way around. Ultimately, Melanie, who enjoyed kindergarten, started to talk about how she did not want to go. Yet, in the presence of myself and others, she really wants to be with other children. 6. I struggled to maintain a normal life for Melanie. I work a normal workday as a human resource manager for Home Depot, which allows me somewhat flexible working hours, and I've been able to go home at lunch to take Melanie to the dentist or feed her lunch on occasion. For over a year, I've taken over all of the cooking, as well as gradually the rest of the housekeeping. Most importantly, if Melanie is to have contact with other children or to be involved in activities out of the home, I have provided it. We play ball together, go to the park, feed the ducks, go to the aquarium, etc. And I would like to involve Melanie in such activities as swimming and school, to which Stacy is opposed due to her fears of germs, food, etc. 7. In late March, Stacy, though herself unable to care for Melanie with her mother, absconded with Melanie to California, without my knowledge or agreement. I was powerless to stop this as I was returning from a business trip from Atlanta. When I left, Janet Wilcox had been acting as nanny, but Stacy asked her mother, Janice Cox, to come in Janet's stead. I was told that Stacy's mother would leave for California the day I came home. Instead, Stacy and her mother left with Melanie 4 hours before my scheduled return. I believe that Stacy may attempt to take Melanie again, and I'm unwilling to allow Melanie to be raised under the conditions which Stacy might provide. This sounds very familiar, as when Charles was away on a business trip, Lori had his truck moved from the airport. She canceled his returning flight and took money out of his bank account. It seems that Janice was involved in similar actions with Stacy, and it doesn't come as a surprise. 8. Stacy's family are inappropriate caretakers for Melanie. Not only does Melanie not want to be there, but I fear the effect of prolonged exposure to them on Melanie. When I finally brought Melanie and Stacy back from California, Melanie had begun displaying rather odd behaviors. She took a pair of scissors and hacked off her hair in a straight line, which she now covers with a baseball hat. She insists she is a boy, and upon meeting new people will insist, "Call me AJ, Alex, or Bobby, and I am 3 years old." When she does that, she begins talking in a different pitch, as if she were 3 years old. Something weird has happened to Melanie. I want to pause here to point out that these behaviors that Melanie was exhibiting are classic behaviors of child abuse, specifically SA. And as an SA survivor myself, I can identify with the behavior of wanting to make yourself unattractive to the opposite sex and wanting to regress backwards in age as to be too young to be of interest to an abuser. I can also identify with wanting to dress in clothes that would make you seem unattractive or seem a different gender. And I'm not making any specific allegations here, but I do want to point out that Melanie's behavior in this situation is not just odd, it's alarming. 9. Stacy has always admitted to me and others that her family was a psychological hornet's nest. She has admitted that her father was diagnosed as schizophrenic and that her mother, Janice Cox, is obsessed with issues of weight, physical appearance, and feminine bodies. Stacy now blames the origin of her problems on food, although it is clear that they originated because of her refusal to administer her insulin program on any consistent basis. Her mother has always been obsessive about any weight gain and about issues of food intake. I cannot help but conclude that those behaviors have contributed to Stacy's problems, and I do not want Melanie to be exposed further to them. 10. Stacy's current condition is her own choice, despite the constant urging of others, lay, medical, and clergy, that she participate in other courses of treatment. Stacy's condition is not just inevitable, but the result of her own opinions and choices from which she cannot be swayed. In 1990, Stacy was diagnosed as a type 1 diabetic, insulin dependent. She must take insulin by shot since her pancreas secretes no insulin and her sugar levels are therefore very hard to manage. Stacy is required to inject insulin, to monitor her blood sugar closely, and to adhere to a regimen of healthy and frequent eating, as well as exercising to reduce her need for insulin. Because she's prone to stress as well as a type 1 diabetic, the disease was difficult for her to manage. Stress increases the body's use of sugar. Rather than following medical advice, she did what was counterindicated. She began eating more, exercising less, and reducing her insulin intake. By the time we moved to Federal Way in November of 1992, the problems with management were apparent, although I'm not certain that Stacy did not just welcome the weight loss as slenderizing. 11. For about 2 years, she managed this regime satisfactorily, although with difficulty, since it involves constant monitoring of sugar levels which vary with amount and type of food, stress, exercise, etc. However, in about October 1993, Stacy enrolled in a naturopathy correspondence course, and since about February 1994, she has refused to administer and take her insulin on a regular basis. She has eschewed the attempts of physicians to help, which have included telling her that she needs antidepressants, that she now needs either intravenous provision of nutrients, an A-line, or direct provision of nutrient to her intestines, a shunt or J-tube. She's attempted to self-medicate her condition with naturopathic medicines. She insists that eating raw garlic before bed, which she also makes Melanie do, is sufficient to ward off disease. She's become paranoid about possible contamination from contact with strangers and their germs, affecting Melanie's participation in a normal social world. The results of this course of action are disastrous, and the effects bear not only on me, but more importantly on Melanie. For example, Stacy has lived with a dangerously elevated level of sugar in her blood. The situation was potentially life-threatening. Stacy's rate is 3 to 4 times normal, and the highest they have seen, according to both doctors Charles Vallow and Larry Stonisweiser, both endocrinologists. By mid-1994, Stacy regarded insulin as the enemy, but by the end of the year, she began obsessively regarding virtually all food as poison. She has suffered dental disease from high sugar, infections including vaginal infection. Because of her failure to eat and fearing sugar, she also developed gastroparesis. Her gastrointestinal system began to shut down, as the nerves were affected by the high sugar. The only way to immediately treat this is by bypassing all or part of the gastrointestinal system, intravenously or by a shunt or J-tube. In the middle of last year, Stacy began fearing sugar, foods, and germs. Melanie's toys must be rubbed down with alcohol periodically, and especially if any other children use them. Although I love swimming, I participated on my school swim teams and wanted Melanie to enjoy swimming. Stacy will not allow her to swim in pools. The germs are there. Our toilet must be alcoholed regularly, rubbed down with cotton balls of alcohol, and Melanie cannot use public facilities. There are germs there. 13. Stacy's problems are psychological as well as physical in cause, but she denies both. Stacy has admitted to me, as well as others, that all the various doctors who have dealt with her endocrine problems have told her she needs psychiatric help as well. In May 1994, Dr. Breiniger, endocrinologist located in Loma Linda, California. In June 1994, internal medicine endocrinologist. Dr. Spratt, whose advice she disregarded in removing the IV without putting in a shunt. She's been prescribed antidepressants on several occasions, but she will not use them, nor will she address the problem. After she was hospitalized 3 times for about 2.5 weeks in December 1994, she had to take nutrients either intravenously or directly administered through a J-tube into her intestine. Each method has risks, but intravenous feeding is more risky because of the risk of infections traveling through the tube to her heart. Before returning home in late June, Stacy refused to have the J-tube implanted and had the intravenous mechanisms removed against doctor's advice. She now will not take insulin to control the sugar problems, nor direct administration of nutrients to deal with the effects of not controlling the sugar. As I understand it, most food passes through her without being absorbed or utilized by her body. Her condition is and continues to be the result of her choices. 14. Stacy's behavior is often out of control. By November 1994, Stacy weighed 76 pounds. As her endocrines and sugars fluctuated, Stacy's behaviors became more erratic. She has had few friends except Janet Wilcox, although some acquaintances through church. In April 1994, in a discussion over medical issues, she came unglued. She began spitting, blowing snot onto me, and threatening to hit me with a mug. I called the police. It was May 1994 when Dr. Breiniger told her she needed antidepressants. At about that time, when we went with my brother and his fiancée, Paula, to a restaurant, Stacy left the table crying and locked herself in the restroom for almost an hour. In September 1994, when I invited my brother and his wife to stay the night, Stacy had another tantrum, 2 hours on the floor screaming and kicking her feet. Other than the hysterical peaks, Stacy is either unable to move or is irritable. Just before Thanksgiving, she lost sensation in her extremities. Both I and Janet Wilcox urged her to go to the hospital. She refused and went to Hawaii. That was the only place that would make her happy or otherwise please her. 15. Stacy collapses, losing feeling in her extremities, a sign of extreme sugar problems, but insists on going to Hawaii. Although I attempted to get her to a hospital, she would not go. Instead, from November 30th, 1993 to December 7th, 1993, we vacationed in Hawaii, going and returning through Los Angeles since her parents live in San Bernardino. I virtually loaded her off the plane and into the Loma Linda Hospital. Stacy had been avoiding taking the insulin. She spent 2.5 weeks through 3 admissions and releases over the next month, and we had to leave Christmas in San Bernardino. 16. I remained in San Bernardino with Stacy in and out of the hospital, but finally I had to return to my job, leaving Melanie with her grandparents, since I believed this was just a temporary situation. Again, her grandparents meaning Janice and Barry Cox. I returned at Christmas for another week, just long enough to help admit Stacy to the hospital for another week. Stacy said her stomach felt like it was devouring itself. In addition to stomach pain, she was weak and fatigued. I went back home, leaving Melanie, but expecting her quick return home. Stacy suffered another collapse and was admitted several times to Loma Linda Hospital between January and early March when she returned home with Melanie. 17. In late December or early January, the doctors had found that as a result of Stacy's high blood sugar, which was killing nerves, and her lack of eating, Stacy had essentially destroyed the ability of her gastrointestinal system to pass and absorb food through the stomach and intestinal system, i.e., she now had developed gastroparesis. Stacy was in and out of the hospital until her return to Seattle in the beginning of March. During this time, Melanie stayed with Stacy's parents and her sister. 18. Stacy has refused both medically accepted methods of providing her nutrients to the detriment of her physical, mental, and emotional well-being, as well as the impact of that of Melanie. In December 1994, Stacy began receiving intravenous feedings via a tube sutured into her shoulder. This is considered somewhat risky medically because of the danger of infection, which, if it comes through the tube, will go directly to the heart, with the possibility of rapid death. Stacy did get a streptococcus infection, and at one point the tube was removed but then reinserted. At that time, she discussed with me the alternatives offered her by her doctors, either the intravenous or J-tube, which allows nutrients to be directly placed into the lower intestine, avoiding problems with the arteries. Stacy refused to use the J-tube, even though she told me that the doctors considered the intravenous feedings more risky due to the possibility of infections. 16. I urged Stacy repeatedly to follow her doctor's advice, but she refused. From December through March, I spent about 8 four-day weekends in San Bernardino while Stacy remained there, in and out of the hospital. In mid-March, she returned home with the intravenous feeding device. She began really obsessing about sugar, telling me she could see the crystals in the fluid bag from which the nutrient drained into her, and virtually warring to keep it out of the house. She continued articulating exaggerated fears related to any contact of Melanie with foods with other children. 19. Melanie now exhibits signs of stress and emotional damage. Most of these behaviors occur in Melanie's presence, and they have affected her adversely. When she's in Stacy's presence, Melanie washes her hands about 25 to 30 times per day, about 4 times an hour. Melanie, though age 6, will now not sleep alone, but wants to sleep in her bed with her parents. She loves milk and cereal, but her mother has decided that milk is bad for her and will not allow her to drink it unless I insist. She's afraid of dentists, although she has had virtually no experience with them. Stacy would not let her go swimming in a swimming pool. It has germs. When Melanie went to kindergarten, Stacy told her that the school and public bathrooms were dirty and that she should not use them at all. As a consequence, Melanie became convinced that she should not go to school, plead ill, and was allowed not to go. Stacy will not allow her to play with toys handled by other children unless they're dipped in or cleaned off with alcohol. I have enrolled Melanie in the 1st grade next year, and I want her to have that experience, free from exaggerated fears about dirt and germs and other children. Stacy either cannot nor will not control her obsessions with these matters. 20. Stacy is... Early in our marriage, Stacy threatened and said she had taken a bottle of pills, but before I called 911, she told me not to, and that she had said this just to get my attention. By October 1994, Stacy began talking again of while I did everything to tell her life was worth living. Nonetheless, she continued to ruminate on the idea. In May, she became more insistent on as a remedy to her problems. Dr. Spratt, then treating her, offered incidents worried me. Stacy had asked a nurse how much insulin she would have to take to go into an insulin coma and die. Stacy soon became quite open with me. On or about May 21st, 1995, judging from my long-distance telephone bill, she called me on the telephone and she said words to the effect of, "Steve, I've done everything that I can. I've talked to Barry and Janice, her parents, and we agree it's my time to go." She then solicited my input on it. On May 22nd, she called and said words to the effect of, "I have no hope, I have no faith. If I have to get another A-line, I'll tell them I just can't do it. I can't hang on anymore. If I don't make it, you'll know what happened. I've given it my best shot." On May 25th, she called and said, "I feel like taking a whole bottle of insulin, but with my luck, I wouldn't die." On May 31st, she phoned me to say words to the effect of, "I really want to die. I would like her to be Melanie's mommy, but I can't do it when I feel like this. I'd rather just let go and die." 21. Because Stacy was in the hospital and I was in Seattle, I could do little except talk to doctors without bringing her back to Seattle, which is what I did at the end of June. However, it was and is my feeling that Stacy has now decided she will die. She was advised to replace the intravenous feeding device, the A-line, with a shunt or J-tube, which is less susceptible to infection by putting nutrients into the intestines rather than the bloodstream. Instead, she instructed her doctors against medical advice to remove the A-line without putting in a shunt. In other words, when she takes in most foods, she does not digest them. At this juncture, my only course is to protect Melanie from inappropriate involvement with her mother's choice of action or inaction relating to her diseases. I have sought help from friends and the church, and I have remonstrated endlessly with Stacy. I could not make her do what the doctors recommended and which she decided against: stay on her insulin regimen, stay on her nutrient regime. The only thing I can do to insulate Melanie from inappropriate involvement in those matters. I believe Melanie needs contact with her mother, but that the contact can only be in the presence of a responsible supervisor. And I want Melanie to be free to be a child and to be taken care of rather than the caretaker of her mother. 23. In June, I demanded that Stacy and Melanie return home, and they did, but Stacy became more demanding and more obsessed. While I made one weekend trip to LA, I could not fly there each weekend. In the meantime, during the week before we left San Bernardino, Stacy had the intravenous tubing removed. She told me it was IV or nothing, and she had decided against IV. 24. Melanie's behaviors become more extreme. Stacy now was alone in the house with Melanie all day, and she would not allow me to hire a nanny. Melanie, who has been raised as a Christian, began using words like shit and other obscenities, as well as wanting to dress only like a boy. Stacy decided she would homeschool Melanie for first grade, which would result in Melanie's complete isolation, since other children are the source of germs and food. Whatever was done in the house, either Melanie or I did, and I was not allowed to bring food except as it was peeled, alcoholed, cooked, and otherwise sterilized in, and then only if it did not contain any sugar. 25. Melanie and I leave. On July 28th, Friday, I told Stacy I was going fishing at Redondo Beach early Saturday morning, about 15 minutes from the house, for about 3 hours. Stacy had another tantrum, yelling, screaming, and carrying on, all of this in front of Melanie. I realized that I could not help her change and that the behaviors which she cannot or will not control are affecting Melanie. I asked Melanie if she wanted to go with me for a ride. When she said yes, I packed up her clothes and belongings. When we left the house, I told her Mommy and Daddy were fighting and it was better to leave than argue. She did not object. We have spent the past week with my brother and his wife, where Melanie has been enjoying normal play with normal children and normal food. I called President Mitchell, who's the president of our church body, Bishop Russell Snow, and Bishop Edwards, and asked that the church look in on Stacy to ensure that she's cared for, insofar as she will allow it. 26. In order that Melanie and I can return to the house, I am asking that Stacy be required to vacate it on or before Sunday night. I've arranged for my mother to come to be with Melanie while I work, either until her first grade begins or until I can find someone for a long-term arrangement. 27. Given her inability to limit her own behavior with Melanie, I'm asking that Stacy's contact with Melanie be only under supervised conditions and limited so that Melanie is protected from feeling like she is the caretaker. Stacy has enjoyed the luxury of making her own choices. Under the circumstances, those choices are now very limited. She can seek intensive, out, or inpatient treatment. She can remain here and continue her existence relying on friends, or she can possibly go back to her parents. I cannot trust Stacy not to talk about these matters with Melanie, and even if she were to agree, I have no doubt that she might enlist her family to convey her wishes. Melanie must be protected from this. This is dated the 4th of August, 1995, and signed in Seattle, Washington by Steve W. Cope. Steve's depiction of his relationship with Stacy and the Cox's influence on Melanie, again, is extremely disturbing. And it's no surprise that just 4 years later, Stacy did die under suspicious circumstances while the rest of her family was in Hawaii. She went into a diabetic coma and was sent to hospice care, where she died just a few days later. Steve was able to bring Melanie to say goodbye before Stacy died. What I'm going to share now is a statement from Steve Cope just following the filing of the divorce papers. This happened on August 8th, 1995, where Barry came into Steve's place of employment, and Steve ended up seeking a restraining order after this incident happened. The statement reads, on August 8th, 1995, at 9 a.m., Barry Cox visited my place of employment. He wanted to discuss the divorce proceedings between his daughter Stacy and myself. He began quoting me scripture and questioning my integrity. It seemed odd to me since he was recently charged for solicitation of a prostitute. His voice got louder, at which time I stood up and told him to lower his voice or leave, or asked him to lower his voice or leave. In front of Marilyn Ayers, my assistant, he continued to verbally attack me. Barry then claimed to serve me divorce papers by pulling my shirt open and ramming 50 pages or more into my shirt. He then grabbed my shirt with his fists and shoved me against the wall. He had his fists and my shirt around my neck. Marilyn Ayers, my assistant, called 911. Barry then left and was cited for assault number 4 and domestic violence. I neither solicited this action nor made attempts to retaliate or attack him. Office personnel witnessed this assault. Barry is currently under an exemplified King County restraining order, and he gives the number. Page 2, line 3 states, restrained from molesting or disturbing the peace of the other party, including third parties. Barry is a third party and has violated this order. Stacy and Steve did end up getting a divorce, and ultimately Steve ended up with full custody of Melanie. He did secret Melanie away from the family for quite a long time. And the family's story at the time was that he was a terrible person, that he had lied in order to get Melanie away from the Cox family, and everyone was supposed to hate him and no one was supposed to talk to him. Melanie was reunited with the Coxes briefly after Stacy's funeral in May of 1998. But Steve did keep her away from the family for the most part for many years after that. It wasn't until her late teenage years, if I remember correctly, that Melanie was allowed to spend time with the Coxes again. Looking back on everything that has happened and everything that Steve detailed in the divorce papers, even if only half of it is true, one could completely understand why he would not want Melanie to be around the Coxes. Following the assault that Barry allegedly perpetrated on Steve Cope at his place of business, Barry filed a document with the court in the state of Washington on August 14th, 1995. I won't share it here because I don't have permission from the person who sent it to me, but this is a court document that was filed and signed by Barry Cox. It says, "My name is Barry L. Cox. This is addressed to the Honorable Judge Commissioner in the Superior Court, King County, State of Washington." It says, "My name is Barry L. Cox. I make this declaration in support of Stacy Cope's motion for primary residential care of her daughter, Melanie. My firstborn child is my daughter, Stacy L. Cope. I'm a practicing financial advisor with BS and MS degree from Brigham Young University and a Juris Doctorate from Citrus Belt Law School. I'm 54 years of age. My daughter, Stacy Cope, married Stephen Cope about 8 years ago, and they have one daughter, Melanie Cope, now age 6 years. During the period of their marriage, I have taken Steve, Stacy, and Melanie on vacations to Texas and Las Vegas and have gone with them on vacations to Hawaii. I have often bought their airplane tickets, rooms, food, and always whatever incidental expenses they have had. We have taken them with us to Disneyland, Knott's Berry Farm, the zoo, miniature golf, movies, water skiing, and out to horse farms. I always believed that we had a close and loving relationship until after Steve left Stacy. I did notice over the years that Steve spent an excessive amount of time working. I am also a hard worker, but have taken time for my family. I would call in the evening sometime to talk to Steve, and he was never there. It was common for him to leave before breakfast and not return until Stacy and Melanie were in bed for the night. I loved Steve and wanted to help him. Accordingly, I warned Steve at one point that his absence and estranged attitude for his wife and child would lead to problems. I told him that a wife was like a delicate flower and needed to have tender love and care, that a husband was like a gardener who needed to provide nurturing care to see the flower flourish and bear fruit. He was indifferent to my suggestions. I could tell from his response that he did not want to be reminded of his spousal or parental responsibilities for Stacy or Melanie. Over the last few months, Steve's interest was ambivalent and inconsistent. Steve is basically a construction worker type with a limited mentality for things of delicacy or of a sensitive emotional nature. He is very good with buildings, lumber, and construction-oriented things, but his ability to understand medicine, disease, or deal with family or financial matters is limited and or below the average. For example, my daughter graduated from BYU with highest scores in her chosen field. Steve, a major in construction management, never did graduate because he could not pass the required basic math classes. On the weekend of July 8, 1995, Steve came to California to visit my daughter and Melanie after a long absence. He said he was lonely and wanted his family to return to Washington so he could take care of them. This was great news to me, and I was anxious for Steve to be more involved with his family. This seemed like a good new beginning, especially as Stacy was getting more in control of her diabetes every day and seemed to have a new lease on life. So Stacy and Melanie returned to Federal Way to their home. Things went okay for a few days. Then things began to decline, and on July 28, 1995, Steve abducted Melanie in the middle of the night and left Stacy alone in the house. Steve also took Stacy's car, her wallet, money, and personal day journal and left her to die. Soon, Steve ordered all utilities turned off and closed their bank accounts. He left Stacy in a desperate state without resources, without ever disclosing to her his intentions. He ran away like a thief in the night. In my view, Steve's actions of cowardice were unconscionable and criminal. I had to rush to Washington to help my daughter. It was obvious that Steve wanted to prevent Stacy from having any resources for the return of her daughter or her own legal help. Steve's legal action filed against Stacy was to have her thrown out of her own home by Sunday, August 6, 1995. He demonstrated in his complaint that his intentions were not that of a gentleman and lacked common decency. Moreover, the allegations about Stacy's medical condition, her mental state of mind, and her ability as a mother are fictitious and designed to accommodate his evil agenda. Stacy is an intelligent, well-educated person. She has devoted her last 6 years to being an excellent mother to Melanie and offered to be a loving wife to Steve. She desires to continue to provide the love and parental care for Melanie. Melanie loves her mother very much and has had an awkward relationship with her father, Steve, because of his lack of interest in her for the past 6 years and his demanding work schedule. Steve's recent decision to suddenly take sincere interest in Melanie and her well-being appears to have had an ulterior motive. I am very concerned for the well-being of Melanie and want her to be returned to her mother's care. Steve has kept Melanie hidden, out of sight, in the care of his friends and family since July 28, 1995, and offered no communication to Stacy or me. All of the allegations about Stacy being a mental case is absurd. The allegations made by Steve Cope regarding me and my wife are false. I was shocked by these malicious statements. It is my hope that the court will examine the facts of this case and, in light of the truth, find in favor of ordering Steve to return my granddaughter to her mother and to require him to take responsibility for her basic financial needs until the divorce is final and to restore her personal property. Please take into consideration that Melanie does not want to have her primary caretaker to be a hired babysitter or her father, who is hardly ever around, or his relatives who live in various parts of the country. Melanie wants her mother to be her primary caregiver. This I know above all else that is true in this case. I know it would be in Melanie's best interest. Thank you for any considerations you give to this letter and for my efforts to offer an objective personal testimony of the facts. Feel free to telephone me, collect for any discussion of these issues. Under penalty of perjury, I declare the above information is true and correct. Now, not only does Barry's letter have absolutely no basis in a legal proceeding of divorce or custody case, this unsolicited narrative paints Barry to be the doting grandfather who pays for everything and Steve to be a delinquent father who was never around. It's basically the preliminary concept of the lower 95, where Steve is just a construction type and he doesn't understand mental health or medical issues. Barry even alleges that his intelligence is below average. So clearly, Barry sees himself as superior to almost everyone, but certainly to Steve Cope. And he's in supreme denial about Stacy, her medical conditions, and what their relationship might possibly be. I find it stunning that at the end of this letter, Barry claims to know exactly what Melanie wants. At the age of 6, that he's able to intuit this is just ludicrous. So later that year, or early in 1996, is when Barry and Janice moved to San Antonio. Lori was working in Austin as a hairdresser and was still married to Billy, and Colby was born at this time. Then in 1999, Barry pled guilty and was sentenced for making false statements to the IRS. He was ordered to serve 1 year and 1 day in prison, and pay over $232,000 in restitution to the IRS. Now, when Janice and Barry moved to San Antonio, they bought that house on Roble Vista and they put it in Alex's name. They were in the habit of putting assets in different people's names to avoid detection by the IRS. For a while, Janice was even the agent of record in Barry's insurance company because all of the legal filings would come back to Janice and not to Barry. So their decision to put the house in Alex's name not only didn't hide it from the IRS, but then it also enabled Alex to do whatever he wanted with it. And in 1999, while Barry was in prison, he did just that. He refinanced the Roble Vista house and took out $175,000 in equity, which he spent on who knows what. So the document I'm now going to reference is the dismissal of Barry's suit against the IRS and various other government entities. In the background information of this lawsuit, we find out what happened when Barry was released from prison. It says, upon his release from prison, Mr. Cox filed several federal tort claims act suits in federal district court against the United States, the IRS, and the United States Department of Justice and the United States Probation Office. All three suits were dismissed, with the district court noting in one of its dismissal orders that Mr. Cox's true intent was to collaterally attack his criminal conviction. Mr. Cox appealed that dismissal order, and the United States Courts of Appeals for the Fifth Circuit dismissed the appeal as frivolous. While that appeal was pending, Mr. Cox again attempted to challenge his criminal conviction based on his contention that he had no tax liability for the 1988, 1989, and 1990 tax years. The district court dismissed the suit, finding Mr. Cox's arguments to be frivolous. Now, before we return to that filing and finish talking about Barry's legal battles with the IRS, I just want to go through a little bit of the timeline of what else was happening in his family during this time. In 2001, Lori married Joe Ryan. In 2002, Tylee was born. And also in 2002, there's a report that Barry's only brother, Jan, passed away, but I can't verify that it is the same Jan Cox that is related to Barry. Then in May 2004, the IRS filed a suit for the back taxes that were owed, including fines and penalties, meaning that the amount that they would now owe the IRS was over $320,000. In 2000, Lori appeared on Wheel of Fortune and the Mrs. Texas pageant. And I remember when she was competing for Mrs. Texas, she spent a lot of money on personal training and outfits and other physical things. And there was a lot of discussion about spending a lot of money to take out ads in the program for Mrs. Texas. And in fact, when she lost, she alleged that the reason she lost is because they didn't take out enough ads. And the winner was the one who took out the most ads in the program, basically hinting that it was a popularity contest or a financial grab where they would only award the winning slot to the person who paid the most for the ads in the program. And while I know that that is sort of a tactic of some of these different pageants, whatever the real reason was that Lori didn't win the Mrs. Texas pageant, she filed for divorce from Joe Ryan just a couple of weeks later. Then in 2005, Barry and Janice filed for bankruptcy, ostensibly under the crushing weight of the debt that they owed the IRS. I attempted to contact the attorney's office who represented them, but sadly, the attorney who represented them in that case has since passed away. In 2006, Lori married Charles Vallow, and in 2007, Alex went to jail for attacking Joe Ryan with a taser during a custody exchange. Then in 2008, Janice and Barry filed suit against the IRS again to have their payments dismissed. And then in 2012, all of the suits and cases were summarily dismissed by the same judge, and now I'll go back to that filing so that we can dig into the details. Going back to the beginning of this filing or this dismissal, summary dismissal, Judge Sweeney was the judge who ruled. It says this lawsuit is the plaintiff's latest attempt to avoid the payment of federal income taxes. Because the plaintiffs have not alleged any facts or cited any law that would bring their complaint within this court's jurisdiction, summary dismissal is appropriate. It sounds familiar to when Judge Boreski recently ruled that Lori's motions had no basis in law. or fact. Very similar. Background. According to the available court records, plaintiff's odyssey began in the late 1990s when plaintiff Barry Cox pled guilty to making a false statement to the Internal Revenue Service in violation of this code. Mr. Cox's sentence, imposed on May 3, 1999, included incarceration for 12 months and 1 day and restitution to the IRS in the amount of $232,914. The restitution included the federal income taxes he owed for the 1988, 89, and 90 tax years. Mr. Cox appealed the sentence, contending that he had no tax liability for those 3 years. The United States Courts of Appeals for the Ninth Circuit rejected that argument and upheld the sentence. Now, I will note here, it's kind of difficult to appeal a case that you've pled guilty to. And I'm not an attorney, but I would just imagine that would be a tough sell. I also want to note that when Barry did go to jail, the family's story was that he was visiting his mother because she was sick. That was the story that Janice had told my dad, who had told me. And when I went to Lori and expressed concern and said, "I'm so sorry that your grandmother is sick," she was surprised. And she said, "What are you talking about?" And when I explained to her what I had heard, she said, "Well, if that's what you want to believe." And later, when I followed up with my dad, I found out that yes, in fact, Barry was serving time at Club Fed. Going back to the document, upon his release from prison, we've already read this part, Mr. Cox filed several Tort Claims Act suits, and I'll skip over that since we read it already. In May 2004, the United States filed suit against the plaintiffs in federal district court to collect the unpaid taxes. In that suit, the U.S. sought a judgment that plaintiffs owed back taxes, penalties, and interest in the amount of over $320,000. It also sought a judgment that its tax liens were valid, that the tax liens could be foreclosed, that plaintiff's property could be sold, and that the sale proceeds could be used to pay down plaintiff's tax debt. As memorialized on the docket and in 3 reports and recommendations issued by the federal magistrate judge assigned to the case, plaintiffs filed a litany of motions and other documents in an attempt to avoid their tax liability. The district court rejected the arguments contained in those filings, concluding that plaintiffs owed the back taxes described by the United States, that the United States tax liens were valid, and that the plaintiff's property could be sold to satisfy their tax debt. As a result, the United States foreclosed on the plaintiff's home, the proceeds were applied to the plaintiff's tax debt, and the district court issued a deficiency judgment against the plaintiffs for the balance of that debt, $206,000. That basically means that they sold their Roble Vista house for around $115,000. That would have been a steal and a good flip for any real estate person. Now, I went back and looked at the sales records of Roble Vista, and nothing goes back before 2005, which means probably those records were sealed. Coincidentally, that's about the time that the Coxes left San Antonio and moved to Arizona or Utah. It's hard to keep track of. There was a time when they were living in Rex's basement for a while, and then they did move to Arizona. I'm not sure how they were able to buy a house. Oh, wait, I do know. We'll get to that in a little bit. In June 2005, while the collection action was pending, the plaintiffs filed a voluntary petition for bankruptcy. The IRS filed a proof of claim for, among other things, the back taxes owed by the plaintiffs. And the United States Attorney's Office filed a proof of claim for the restitution owed by Mr. Cox as a result of his criminal conviction, which included the same back taxes sought by the IRS. Throughout the bankruptcy proceedings, the plaintiffs continued to advance their argument that they had no tax liability for the 88, 89, and 90 tax years. Plaintiffs eventually voluntarily dismissed their bankruptcy petition. The IRS then sent the bankruptcy trustee a notice of levy with respect to the funds being held by the trustee on the plaintiff's behalf. The plaintiffs challenged the IRS's authority to issue notices of levy, but the bankruptcy court concluded that the notice of levy sent to the trustee was proper and directed to the trustee to turn over the funds in his possession to the IRS. Then, in June of 2010, Mr. Cox filed suit in another federal district court against, among others, the United States Department of the Treasury Inspector General for Tax Administration, and the IRS, challenging his income tax liability. The district court rejected Mr. Cox's arguments and dismissed the suit. Plaintiffs subsequently turned their attention to the United States Court of Federal Claims. On June 13, 2012, 13 years after Mr. Cox was ordered to pay back taxes to the IRS as restitution, the plaintiffs filed the instant suit. They allege a wide variety of claims in their rambling 106-page complaint, but the bottom line is that they do not believe that they are required to pay federal income taxes. They seek actual damages equal to the value of their property leveled by the United States, punitive damages, statutory damages, an award for pain and suffering, declaratory and injunctive relief, and attorney's fees and costs. Plaintiffs also demand a jury trial. Notably, plaintiffs do not seek a refund of any income taxes that they have already paid. So basically, this judge goes on to talk about the fact that they don't have jurisdiction over this particular case. The United States can't really be held as a defendant, and then they go on to address the plaintiff's allegations. Plaintiffs allege that the United States has violated several amendments to the United States Constitution, a wide range of federal statutes, and a number of federal regulations, clearly disregarding the limited ability of the Court of Federal Claims to entertain suits against the United States. It's axiomatic that the United States, as a sovereign, is immune from suit, save as it consents to be sued. The waiver of immunity cannot be implied but must be unequivocally expressed. The Tucker Act, the principal statute governing the jurisdiction of this court, waives sovereign immunity for claims against the United States not sounding in tort that are founded upon the Constitution, a federal statute or regulation, or an express or implied contract with the United States. However, the Tucker Act is merely a jurisdictional statute and does not create any substantive right enforceable against the United States for money damages. Instead, the substantive right must appear in another source of law, such as money mandating constitutional provision, statute, or regulation that has been violated, or an express or implied contract with the United States. Thus, the court analyzes whether the amendments, statutes, and regulations cited by the plaintiffs constitute money mandating sources of jurisdiction. Plaintiffs allege that the United States violated the rights afforded to them by several amendments to the Constitution. First, they contend that the United States violated their right to redress their grievances under the First Amendment. However, because the First Amendment standing alone does not obligate the United States to pay money damages, it cannot serve as the basis for jurisdiction in the Court of Federal Claims. Second, the plaintiffs allege that the United States violated their right to due process under the Fifth and 14th Amendments. Sound familiar? But because neither due process clause is money mandating, they do not provide a basis for jurisdiction in this court. Third, the plaintiffs contend that the requirement to submit an income tax return to the IRS under penalty of perjury violates their right against self-incrimination under the Fifth Amendment. Again, it's a misinterpretation of the law. The Fifth Amendment's self-incrimination clause, however, does not provide for money damages and therefore does not constitute a basis for jurisdiction in the Court of Federal Claims. Finally, the plaintiffs contend that the United States tax liens and levies constitute unreasonable seizures of their property under the Fourth Amendment, but like the other amendments relied on by the plaintiffs, the Fourth Amendment's search and seizure clause does not mandate the payment of money damages. Therefore, it cannot provide a basis for jurisdiction in the Court of Federal Claims. In sum, the court lacks jurisdiction to entertain the plaintiffs' constitutional allegations. Then, the plaintiffs went on to allege criminal conduct, tortious conduct, mismanagement, and incompetence, and none of those things can be remedied by this court. 7. In general, the plaintiffs' allegations amount to nothing more than a collateral attack on prior judgments establishing their federal income tax liability and permitting the United States to recover those taxes that they have not paid. The plaintiffs in each of the previous cases in which they were involved had the opportunity to appeal the judgments, and they either appealed and lost or failed to appeal at all. They cannot now attack those judgments in the Court of Federal Claims. The court goes on to say that they're not entitled to relief because they haven't asserted any claims against the United States over which this court has jurisdiction. Then finally, it says the court has combed through the plaintiff's complaint and has not been able to discern any claim over which it could exercise jurisdiction. Accordingly, for the reasons set forth above, the court dismisses this plaintiff's complaint. And this was in 2012. I love this little footnote down here at the bottom. Even if the court possessed jurisdiction over the plaintiff's complaint, almost all of the plaintiff's substantive allegations are frivolous. Indeed, they amount to nothing more than pedestrian tax protester fare. It is well established that such contentions lack merit. So just after the dismissal of this final suit by the Coxes, the IRS in 2013 filed liens on Barry Cox, Janice Cox, Alex Cox, and all of their properties and assets, which included a strip center in Santan Valley. I'm curious about where they got the money for this. Oh yeah, it's because they didn't pay their taxes. Then in 2018, the state of Arizona had to file a cease and desist order after Barry advertised estate planning services. Now, Barry has never passed the bar nor held a law license in Arizona. And the news release of this event reads, a flyer reading estate planning documents was left on several Santan Valley residents' doorsteps listing a menu of services and identifying Cox as, quote, Barry L. Cox, Esquire, legal document writer. In the state's complaint, the bar asserted that offering estate planning services, identifying himself as a legal document writer, and using the Esquire designation for lawyers led the public to believe that he was authorized to practice law in Arizona. He was not authorized to practice law in Arizona, and so he received a cease and desist order from the state of Arizona. Just two other things to cover here is that, so by 2018, Janice and Barry were living in Santan Valley, which is the same area of the Phoenix suburbs that Alex was living. This enmeshed family continued to live very close to each other, and Barry and Janice apparently had a lot of control over what went on with their children and their children's spouses. For more information about how involved Janice and Barry were in the plot to kill Charles Vallow, you can see the video where I read through all of the text messages in the FOIA documents from the Chandler, Arizona case. Now, despite the fact that Charles Vallow was killed in July of 2019 and that Lori left Arizona in August of 2019, cutting off contact with her parents and her siblings except for Alex, and moving to Idaho with their grandchildren missing, Barry found time to self-publish his book. His book, How the American Public Can Dismantle the IRS, by Barry L. Cox, was published on November 26th of 2019. Think about the timing, the stunning timing of that book being published. You can read almost the entire introduction in this sample. Rather than try to summarize anything about what I think about the book, which I never finished reading, I'll just read to you a little bit from this introduction, which is publicly available on Amazon. The author has written and published this nonfiction book to reveal to the American public overwhelming and irrefutable evidence of the IRS fraud and what the people of the United States can peacefully do about it. The contents of this book are protected under the right of free speech as guaranteed by the First Amendment to the Constitution, cites case law. Warning. The information in this book is highly controversial. It contains material that is factual and somewhat political. The author has presented his assessment and professional opinion. What profession would that be? That show the IRS, DOJ, and federal judiciary and other federal government entities of the United States government in Washington, D.C. are unimaginably corrupt. There are lots of words in all caps. There are lots of run-on sentences, and Barry refers to him throughout the book as the author. I'll skip a little bit to this section. If the reader is a person or individual that believes they are taxpayers obligated to pay a federal income tax to the IRS upon demand and who thinks or believes the officers, employees, and elected officials encrusted in the deep state or swamp of parasitic bureaucrats have the right to impose and collect a federal income tax upon the salary or wage of the American citizens, then stop. I actually forgot how the sentence began. If the reader is easily offended by light and truth, a Mormon phrase, or believes the federal government works for the best interest of the American people and are honest men and women who wouldn't knowingly and willingly conspire to harm or destroy innocent citizens of the American public in order to get personal power and control or to make financial advantage over the American public by imposing an illegal and unconstitutional tax schism without the consent of the governed people of the United States of America to promulgate the biggest lie ever perpetrated on the citizens of the most favored nation on earth, then stop now and discard this book. Skipping a little bit to incorporate how important religion and Mormonism is to Barry Cox, apparently. American law is unique. It is predicated upon the inspired words of God the Father, the creator of all things, who personally appeared to Moses to give the Ten Commandments as written and published in the Bible's first 5 books of the Old Testament, as recorded and written by the ancient prophet Moses in face-to-face revelations with God in the Egyptian desert on Mount Sinai. This is assuming you know nothing about the Bible. These laws were intended to peacefully govern the liberated tribes of Israel from 400 years of bondage under the despotism of the pharaohs of Egypt. See the Bible's Old Testament book of Exodus, chapter 20. I'm not going to quote that. The author begins this lengthy book with a reminder to the reader of these historical and important historical events, which promulgated the God of heaven to bless this American nation as a choice land above all others in the world. The reader will be wise to accept the documented facts referenced in this book and respect the origin of the laws of the United States. To be certain, this nation's laws were predicated upon men who had faith in the God of heaven and in the Savior Jesus Christ, as stated in our anthem, "One nation, under God, liberty, and justice for all." The obvious lies of President Barack Obama are evidence that he was the most corrupt of all the presidents of the United States, including Nixon, and was anti-Christian. He thus proclaimed his belief that America is no longer a Christian nation. Mr. Obama told the American public when he was running for the presidency that he was a Christian and believed that marriage was a sacred union between a man and woman. That lie dramatically changed when he admitted his Muslim education and his background with the LGBTQ society. I'm not really sure what the LGBTQ society is. I'm going to just stop here before I lose any more brain cells. Now, you would think that this would be the end to the Cox IRS saga, but it's not. According to the website, the FOIA Project, they're still gathering information for a new lawsuit. According to the FOIA Project, there is a case pending that was filed on March 3rd of 2020 with their daughter Lori in jail. Now, with Janice and Barry Cox as plaintiffs, the description of the case is that Janice Cox submitted FOIA requests to the Department of the Treasury, the Tax Inspector General for Tax Administration, and the IRS for records concerning whether she was subject to tax laws. The agencies acknowledged receipt of the request, but after hearing nothing further from the agencies, Cox filed suit. The complaint issued was a failure to respond within statutory time limit, adequacy, search, litigation, and the Vaughan Index. They named as defendants the following: the Department of Treasury and Tax Inspector General for Tax Administration, the Department of the Treasury, J. Russell George, Stephen T. Mnuchin, Secretary of the Treasury, and the Internal Revenue Service Commissioner. Most of those defendants were terminated in May or June of 2020, just after the suit was filed, meaning that they weren't subject to the lawsuit. In this annotation, the FOIA Project notes this: the judge has ruled that the suit brought by husband and wife tax protesters Janice and Barry Cox against the IRS, alleging the agency did not disclose under FOIA the statutory bias for paying income tax, should be dismissed for a failure to exhaust administrative remedies. The Cox's suit also asked for $480,000 in damages for 30 years of taxes improperly confiscated by the agency. The judge explained that although exhaustion under FOIA is not a jurisdictional requirement, FOIA's administrative scheme favors treating failure to exhaust as a bar to judicial review. Therefore, a plaintiff's failure to exhaust before filing suit can be substantive ground for rejecting a FOIA claim in litigation. The court should not consider the merits of an unexhausted claim if proceeding would frustrate the purpose and policies underlying the exhaustion requirement, namely to prevent premature interference with agency processes, to give the parties and the courts benefit of the agency's experience and expertise, and to compile an adequate record for review. Addressing the Cox's claims, the judge observed that the defendant located several of plaintiffs' FOIA requests from 2009 and 2010, and one request from 2019. It disputed that 1, the defendant responded timely to each request within 20 business days, and 2, the plaintiffs did not exhaust their administrative remedies pursuant to the Treasury's FOIA regulations. If you're interested, I will put the link to the FOIA project down here. You can read every single filing on the docket and all of the minute entries as well if you're interested in digging into it. But frankly, it seems like a huge waste of time, and I have already wasted too much time reading all of Lori's legal briefs and garbage. I just want to end with a couple of personal thoughts. Going back to the divorce of Steve Cope and Stacy Cope, detailing what Melanie went through as a young child, one could possibly understand why she would align herself with Lori. In a subsequent video that I made regarding family matters and Melanie's involvement in the case, I wrote the following. Melanie was separated from her mother at such a young age under traumatic circumstances. Stacy must have become a legend to her, imaginary and infallible. Melanie's formative years were spent with her father, who alienated her from her mother's family. Justified or not, that alienation bred resentment in Melanie. So when she had an opportunity, she naturally felt compelled to reconnect with her mother somehow, and found that the Coxes welcomed her with open arms. They likely commiserated with Melanie over her father's shortcomings, and she likely found solace for her mother wound by being embraced and accepted in Barry's home. Melanie likely felt heard for the first time about her sadness from being separated from her mother and her frustrations with her father. A mother wound creates a unique void in the life of an abandoned daughter. The daughter can develop codependent behaviors such as having poor boundaries, an excessive need for praise and approval, people-pleasing, a weak sense of self, conflict avoidance, and difficulty being alone. These behaviors soothe the mother wound. For example, a wounded person might develop an identity as a people-pleaser because it garners them praise and approval, helps them avoid conflict and boundary setting, and pleasing may make them feel accepted by others. The wounded person also tries to control the amount of negative feedback they may receive by accepting assignments to donate time or labor to organizations because most reasonable people will withhold fault-finding when someone is working for free. Many times the wounded person does this to the detriment of their own well-being and their personal relationships. The abandoned daughter develops these behaviors as a coping mechanism, but the behaviors leave the individual susceptible to manipulation and coercive control. They may even engage in manipulation themselves in an effort to control their image and gain acceptance. Instead, the abandoned daughter can reparent themselves through inner work, clearly defining a sense of self and revisiting the wounded child to provide them with the encouragement, acceptance, and validation they never received. These thoughts that I have about Melanie may explain the reason why she attached so tightly to Lori and adopted her beliefs really without questioning. Now, I'm not trying to excuse any of Melanie's behavior, any of Lori's behavior, or any of the Cox's behavior in any of this. All of this information I bring forward in an effort to try and understand how we got here, and in an effort to help people heal their emotional wounds so that we don't ever have to be here again. The Cox family is an authoritarian system. It is an enmeshed family, marked by a high degree of loyalty and an inability for the members of the family to individuate or form their own identity. When children over-identify with their parents and mimic their actions, their behaviors, and adopt their beliefs unquestioningly, the enmeshed family can continue to perpetuate harmful dynamics for generations to come. Adam recently said on one of his podcasts that the whole reason he's doing what he's doing and the purpose behind his mission is to get families to talk to each other, because that's how we got here in the first place, is that Lori was doing all this crazy stuff and nobody was talking about it or talking to her about it. Adam certainly felt on the outside during this time. He was the only one who was willing to talk to Charles. But even more important than communicating with each other about harmful things that family members might be engaging in is an ability to radically accept what might be harmful or dysfunctional in the family's relational patterns. It doesn't do us any good to talk to each other if one or more of the family members is still in this enmeshed mindset that they can't differentiate or say anything contrary to what the family believes. Now, I've certainly had my share of fallout from the truths that I'm speaking and the things that I'm talking about, and it's one of the risks of being a truth teller in a family system that refuses to look at the truth. The truth hurts sometimes, but a family is as sick as its secrets. And as long as there are still secrets in the family system, communicating isn't going to fix it. The only thing that does fix it is when individual members of the family start to look at their own flaws, their own faults, and their own weaknesses. It happens when individual members of the family start to heal their own emotional wounds. It happens when individuals of the family put truth above loyalty, and when people are willing to confront their own fear, guilt, and shame. As long as fear, guilt, and shame are running the show, in other words, driving what makes you make your decisions, the unhealthy relational patterns are going to continue and persist. It took me a long time before I was willing to confront the dysfunctionality in my own family of origin, and it was very painful to do so. I had a lot of resistance to it, but the alternative is continuing to believe the lies and participate in the dysfunction. I, for one, just got to a point where I couldn't do it anymore, and where I recognized that it was detrimental to my mental health and to my relationships with my children. I'm hoping that these conversations are going to start ending the stigma against seeking mental health treatment, because all of us have unmet emotional needs. All of us have emotional wounds. All of us were raised by parents who didn't do it perfectly. And all of us are parents ourselves who aren't doing it perfectly, even if the only person we're parenting is our own inner child. I don't claim to have all the answers. I don't claim to know everything, and I'm certainly not perfect. I've been very open about my flaws and my shortcomings and my struggles throughout this family saga. I don't really have a lot of hope that my personal family, whether it's my family of origin or my extended family, are ever going to truly heal from all of these generational wounds, because it seems like there is a lack of willingness to dig into the actual truth. And frankly, denial is easier and less painful. But I hope that by speaking up about these family dynamics and helping people to realize that it goes back for generations, I really hope that people will start to embrace their own family's difficulties and address them and confront them head on. Having a willingness to dig into the difficult conversations that need to be had is one of the first steps, but seeking help from qualified mental health professionals is a critical component as well. All of us could use a little therapy. If you're inherently distrustful of the profession, like many people are, there are lots of really good books out there. And one of the ones that I recommend for family systems like this is called Running on Empty. It's about childhood emotional neglect, and it's by a woman named Dr. Jonice Webb. It was one of the first books that I read in my therapy journey, and it helped me to understand the dynamics between myself and my parents and myself and my siblings. It's just one place that you can start. It's one small thing that you can do that may just become revolutionary. At the end of my shows, I always advocate for people to be kind to each other, but mostly to be kind to yourself, because we have to forgive ourselves for what we did when we were in survival mode. We have to forgive ourselves for the mistakes that we've made and for the times that we've acted out of our own emotional wounding and hurt other people. But the sooner that we can embrace those mistakes and start addressing them, the better off we will be. I'm always an advocate of doing the thing that is the most loving for yourself, and sometimes that means confronting emotional wounds and doing difficult work. All of that said, if your family has secrets and deep wounds, if they're dysfunctional in any way, my encouragement is for you to start with yourself, because we can't do anything to help others unless we help ourselves first. Hello, beautiful human. Thank you so much for watching today. Would you do me one quick favor and take a second to subscribe to the channel? It's the best way that you can support the channel for free. In addition, if you're interested in even more exclusive content, you can join the community at the link below. Thanks so much for being here.